and you guys are very welcome to be involved in this. I'd like to involve and invite my fellow panelists. Firstly, I'd like to invite Mr. Antonin Sobek. He's the counsel for DICF and LCIA Arbitration Center. Antonin, please come on stage. Next, we have someone who I deeply admire, Mr. Felipe Marquez, the legal director, IMETA and CHEP, UAE. Something that you guys must know about Mr. Marquez, that in terms of the knowledge that he brings out over here, because he's worked across the planet from South America to the UAE, to US and everywhere. So that's something that he's bringing on. I'd like to now invite Mr. Santosh Kumar Singh, sir, Head of Legal and Ethics Compliance Governance in Gentig. Sir, we had a very crisp conversation today, me, sir, and of course, Ali was also there. We had this conversation. Sir has also worked with the CRPF in India, and now he's taking on the legal strides of this very, very big company. I'd like to now call upon stage Miss Mumtaz Bhalla, who is the partner at one of India's leading law firms, Economic Law Practice, ELP. And I've been told that we are joined by Dr. G.V. Rao, Senior Advocate, designated as the Supreme Court of India. How are you, sir? It's great to have you here, sir.
Yeah, I'm here. Can you hear me?
Yes, sir, you're very audible.
Thank you.
So I'd like to start the session, firstly, by introducing my fellow panelists. One by one, I'd like to start with Mumtaz first. Mumtaz, you all have 2 minutes to introduce yourself, what you're going to be speaking about, and we'll take it from there.
Hi everyone, my name is Mumtaz Bhalla. I'm a litigation partner with Economic Laws Practice, a firm based out of India. My practice area primarily includes civil and criminal litigation and arbitration. In this session, I'm going to be talking about inclusion of IBA rules of conflict in our Indian Arbitration Act and how our arbitration law has shaped up post the Indian courts getting very, very particular about issues like independence of arbitrators. Then how do they react on the issue of emergency arbitration awards being enforceable in India in terms of Section 17. So yeah, that's what I'm going to be talking about, because these are the hot button issues in India. Thank you.
Yeah. So,
hi everyone, my name is Santosh Singh. I'm heading the Legal Compliance and Governance Department for Getting. Getting is a Swedish multinational company, and I'm responsible for Middle East, Africa and Asia Pacific region. So Getting is basically in the medtech devices. We make popularly the ventilators. So we were quite busy for last 2 years. And I will be speaking about some of the, because I'm an in-house lawyer, so I think Mumtaz and other people can give more inputs about the actual arbitration proceeding, but I'll be speaking more about pre-arbitration parts, that what we need to do before we actually start putting the arbitration clause in our commercial contract. So that is the part which I will try to give you some tips and other things with my own experience, because I have done few corporate arbitration in my corporate career. So I know that how to trigger, how to start with it. So that's the thing I'll be covering.
Good afternoon, everyone. Felipe Arboleda. That's how you pronounce my name. I'm legal director for CHEP. It's a pallet pooling company. It's involved in the supply chain of everyday goods. Everyday, all the supply chains have to go through a pallet to get to a store. That's where a company like ours come in. I've worked in many regions. I've worked in South America. I've worked a little bit in the United States, and now in this fascinating region of the Middle East, Africa, getting involved every day a little bit more with India. Also going to share a couple of in-house tips on the financial aspects about arbitration. That's not entirely the legal aspect, but what finance, the finance details of arbitration.
Good afternoon, everyone. So, Somesh kindly introduced me as counsel at the DAFCLC Arbitration Center. I should clarify that it was true until the end of last week. This center does not operate anymore, and I have been transferred now to Diac at the Dubai International Arbitration Center. So the title of this panel discussion refers to hot button issues of commercial arbitration. And I believe that decree number 34 of 2021 regarding the Dubai International Arbitration Center is one of these hot button issues, especially here in this region. So some of you may know that this decree basically abolished the DIFC Arbitration Institute and the Emirates Maritime Arbitration Institute and transferred all the property, employees, rights and obligations to Diac. Now, Diac had until the 20th of March of this year to basically comply with all the provisions of this decree. And given the fact that now this transitional period is over, I will be happy to address some of the issues arising out of this decree. But let me just emphasize that today I will express my own personal views and I will not speak on behalf of either DIFC-LCI or Diac.
Right. Thank you, Antonin, for the clarification. Let me start off by basically, if you guys don't mind if I stand, right? Because if I'm sitting, I'm not able to see Antonin from this far end. So when I want to start about, let's start with Sandeep, sir. So you spoke about how this is going to be a discussion about we are in the nascent stage of drafting the arbitration clauses for these contracts. And I personally feel it plays a vital, very pivotal role in terms of that. Yes. So I'm so sorry, I think GB also, my instructions was left. Could you, sir, just start the thing?
Did I hear my name? Excuse me.
Yes, sir. I'm terribly sorry, sir.
I think the audio, there is some issue with the audio video. I'm not able to hear clearly, but can you hear me clearly?
Yes, sir.
Can you hear me clearly?
Yes, sir, I can hear you very clearly, sir. Please go ahead.
Yeah. I'm a lawyer in Delhi. I'm a senior advocate of basically in the Supreme Court, but I've been practicing everywhere else. I'm now currently the vice president of the Indian Society of International Law. So I've done a lot of work in international law areas in various aspects. I've done some international commercial arbitrations also, and I've known some of the venues where international commercial arbitration takes place. And I'm currently dealing with a particular issue which I want to talk about, and I've written about it, and my advice was sought about it regarding a arbitration that was taking place in Singapore. So I would like to, touch upon the India scenario with respect to international commercial arbitration and the obstacles that some of them that are being posed, and which I've written in my article. And that's what I would like to discuss.
Thank you so much, sir. I would just request Sandeep, sir, start with the question.
Santosh.
Santosh, sir. Sorry.
Okay, I think it's interesting to talk about the pre-arbitration stage. So it's always a very important topic for all in-house lawyers when we are working on any of the commercial contract. So what type of jurisdiction, what type of things we should put up in the contract. I think most important question is to decide, are we going to put arbitration or we are not going to put arbitration? I think there is a lot of questions we need to ask ourselves as an in-house lawyer when we are actually deciding that we will put a dispute mechanism as an arbitration. Because arbitration, although it's a very interesting thing, it's an alternative dispute mechanism, it's becoming very popular. And I know that when we talk about arbitration, especially in the law school, we are told that it's basically the cheap alternative, which is a total myth. Arbitration is not at all a cheap alternative. It's actually, in some countries, it is more costlier than the normal jurisdiction process. So my advice to all of in-house counselors would be that when we are trying to look into and trying to see that whether we can go for arbitration or not, we should look into, first of all, the cost aspect, because arbitration is not going to be cheap. So if a contract which is like not very commercially, not with high value contract, at least I will not put arbitration clause in a contract which is not very commercially high value. So one aspect is to look into whether the commercial value of this contract support us to go for arbitration or not. So that's very important. So low value contracts, no value commercial contracts are not very suitable for putting in arbitration clause, because especially, and again, then depending upon which country you are actually operating, because if you are operating in some of the standard legal jurisdiction, you will definitely have more advantage to go with the normal legal remedies instead of arbitration, if it is a low commercial value contract. Or another aspect you can look into apart from commercial value, whether this contract has got something which can actually create sort of a reputational risk for you. So if it is a reputational risk, so definitely with the big companies, I think then commercial value will become irrelevant. Then we would definitely like to go for arbitration, because arbitration, the advantage what I feel is that we can actually have more control on the proceedings, because in the normal legal jurisdictions, and especially depending on, because if we work in an international environment where we have got parties which are operating in a different countries, like we are in one country and another party of the contract is another country, then arbitration becomes rather more easy and important, because then it's more like both the parties are having a fair chances. Another aspect which I would suggest we have to think about putting arbitration clause is to look into, if one of the party is in another jurisdiction, especially in another country, then we need to look into whether that country is a signatory of New York Convention or not, because that's also very important. If that country is not signatory of the New York Convention, so even if you go for arbitration, you won the arbitration, but then implementing the arbitral award would be very difficult. So another tips, what I would say, that to check whether it's country New York Convention, and also very important thing which we need to look into, what type of disputes we are trying to solve through arbitration. What type of commercial contract is this? Because many of the jurisdictions, even if they are signatory for the New York Convention, they have got so many restrictions on implementation of arbitration award, especially if any of the arbitration award is violating the public policies. Like I have seen it many, especially in the Middle East region, we have seen that there is a strict restriction that if a foreign jurisdiction or an arbitration award is going against a public policy, it will not be implemented. So we have to look and see, violation of public policy can be very simple, because in some countries, for example, in Saudi Arabia, asking the interest is actually violation of a public policy. So if your arbitration award is going to award you some penalties, including the interest, then your award is useless, because then it will not be implemented. So we have to be carefully examined before we decide that we have to put an arbitration or not. And if all these tick box are yes, 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 then we are deciding that, okay, we are going to put the arbitration in the commercial clause. Most important thing, we need to actually see that which arbitration or which jurisdiction we are going to have, whether we are going for a DIA, like Dubai arbitration, which we used to call it DIFC, or we are going for London Chamber of Arbitration or ICC. So we have to actually decide, because these are the things depending on which countries the parties are operating. Like if both the parties are in UAE, I would definitely say that the DIA is very good. We can actually go for it. But if the one party is in New York, one is there, then maybe you choose the New York arbitration or London. So depending on that, where are the parties, we have to decide it. And finally, as an in-house counsel, the most important is what type of arbitration clause you are putting. How clarity you are giving in the arbitration process, because your clause will finally come very handy when you will finally go to the arbitration. If your clause is clear, if you are actually defining the roles, responsibility of the arbitrators, if you are clearly defining everything in the clause, so it's an exercise which we need to do it before we finally, because it's not just, okay, let's keep the arbitration a standard clause for all our dispute resolution. So we have to go in detail before we deciding that we are actually putting in arbitration as a dispute resolution method in our any commercial contract. So that.
Thank you, sir. That's very, very insightful. And to be very honest, sir, the way you've brought this out, I think this is something that we really need to understand as law firms, as drafters of contracts, because I think a session or two before us, Ali sir had spoken about how we are the drafters of the contracts and we have to really understand what exactly we are looking at. If you don't understand the business, you can't understand the contract, and then you can't draft the arbitration clause with reference to whatever dispute. A very interesting point, sir, that you raised, because you said that arbitration, what we were sold initially when arbitration came into being, there was a big boom about arbitration. They said that, arbitration is going to be the cheap way of, dispute redressal. I think Felipe would like to, could you please, enlighten us on that? And as to how the financials, for example, I need to know, or even all of us want to know, that when there is a dispute, right, and as a GC what you see, what are the first two things that you understand for financially, how viable, as sir mentioned, the jurisdictions, the enforceability, and towards the fag answer, I'd like to just add one more on my side. I'd like to see when do I get my money back? That's the bottom line. Arbitration is a mechanism which is supposed to be cheap, which is supposed to be very fast, it's supposed to be very effective. All of this is good, everything's hunky-dory, well said. But when do I get the money back that's the question. So could you please enlighten us on the financials on the side of the entire process?
Absolutely, and thank you for asking. So I guess lawyers have a lot of experience in calculating legal fees and the costs of a potential arbitration. Especially nowadays, what I've seen is that law firms have been very creative in giving clients a very good estimate on how much an arbitration or potential litigation could cost. When I started my career, it was always difficult to get that from law firms. I think the law firms in general have evolved and have a much more certainty of the cost of our arbitration and litigation in general. That's a good step forward, but that's always, of course, number one. When your CFO asks you about going into a potential claim, well, the number one question is going to be how much will it cost? So that's number one, legal fees. The second aspect, and I guess for everyone in the room, everyone is very aware of this, the second cost is the arbitration costs. You are very right in that in some jurisdictions, arbitration could be seen as a cheaper, less expensive dispute resolution mechanism. That's not the case in every region. In some other regions, it's actually much more expensive to go to an arbitration. Sometimes the arbitrators get very hefty fees of a given award, and that becomes much more expensive than just going to the ordinary jurisdiction in a given country, especially in countries like South America, South Africa. Arbitration is much more expensive. But again, here, I think arbitration centers have done a good job on putting their rates online. So it's relatively easy for you as in-house counsel or external lawyer to find out how much will a given arbitration cost in a given jurisdiction. So you have from one side, you got the legal fees from the law firms that are doing a relatively good job on giving you a fair estimate. Then you have the arbitration panel or the arbitration center giving you fees. That's point number two. But then the biggest aspect that I guess as lawyers sometimes we forget about is the accounting of a given dispute once it gets to arbitration. So, and let me just pause a little bit here because that's probably the main point I wanna transfer to the audience here. If you have a claim, depending on what stage of that claim in your company records, that claim has a different accounting treatment. So if you have a potential contingency before an arbitration or before a settlement or before a mediation, it has a way different accounting treatment than that same contingency once that contingency is in a given arbitration. So just give you a very quick example of how would this work. Very oversimplified example. Of course, there are many issues in every single litigation. There's always third parties, insurance risk, you name it. You can complicate things. But just to give you an example of how this works, just to make sure I convey the message. Let's say party A has a contract with a party B. sale of goods, the goods are dispatched, the goods are there, the invoice is there, the PO, everything is completed on time, by the book, everything is there. In the books and records of party A, you have a revenue recognition, that means you have an asset in your balance sheet, and then you have revenue in your P&L. Everything is fine, life is great. If you are party A, you could even have given bonuses, commissions to your salespeople, everyone's happy. If by any chance party B doesn't pay, that revenue starts becoming a contingency. If you move to settlement discussions, that contingency starts to become more of a contingency for accountants. So if you get an auditor in your company and they start asking questions about that revenue that you got from that big sale, they're going to start asking questions about why didn't you put some accounting provision, some sort of reserve. Big CFOs of big companies that have, let's say, international accounting standards will start making accounting reserves or accounting provisions, because that revenue is no longer a revenue. You have to start making provisions because it's becoming a contingency. Let's assume in that scenario that you didn't settle, that revenue that you saw, those goods that you saw are not getting paid, party B is not getting paid, is not making payment, then that's the third stage. You would probably go to arbitration. If you go to arbitration, then 100% of that revenue becomes a contingency. It's 100% uncertain if you will get that money back, and that would be a huge blow for any company's financial records. Because if you made a sale that you recognized in fiscal year X, but then all of a sudden that same revenue now becomes a huge liability because it's uncertain, it could destroy a company's financial records, and it's usually something that lawyers don't think about. Usually lawyers think about more about the cost of going to arbitration rather than the impact in the financial statements of a given arbitration or a given litigation. So my message here is, every litigation has its details. Every litigation has issues. You can overcomplicate things. But in general, my advice and the point I want to hammer in this presentation or in this talk is, talk to your financial guys, talk to the accounting guys. Whenever you have the decision to arbitrate or mediate or go into a claim, it's better to have those things understood before you start and not afterwards, because afterwards could be a little bit too late. I hope that was good enough for the answer.
Thank you so much, sir, because this is something that we always wanted to understand, because we as external lawyers, we always have that dilemma, right? Because we as lawyers that we are was outside the company, right? We face this dilemma as to when the arbitration becomes too expensive, and how the entire situation has to be studied beforehand, and you need to understand as GCs in that way whether or not this is financially viable, this is implementable. And thank you, sir. Thank you for those views, sir, because I think that is something that's a very big takeaway for at least me once we go back. Thank you so much, sir. So, I'd like to have another question with Antonin, because while I was reading about the various things that you've done, Antonin, ladies and gentlemen, Antonin has been working in the UAE for a very long time. So, Antonin, just one question. When the Dubai International Arbitration Center, Diac, the new rules have just been framed, what are your views about that? Because I understand that from where I come from, we of course have different arbitration centers, of course, in India. Now we used to heavily rely on the Singapore International Arbitration Center and of course Hong Kong and London. But what are your views about the new set of rules that have been come out? And there's there's a part to this question, because I need to understand this, and this is something very important. What happens to the contracts that have been entered earlier with an authority, with an arbitration center, which is no longer in existence? To give you a perspective, ladies and gentlemen, this is about, so for example, there are two parties, an illustration, there are two parties who enter into an arbitration agreement, and they have a standard dispute resolution clause about referring it to maybe Singapore International Arbitration Center, and at some point in time, Singapore Arbitration Center ceases to exist. What happens to the arbitrations who are still going on? What happens to the arbitrations that might occur later? So this is a two-part question, Antonin, and I'm sure you will take it from there.
Thank you very much, Somesh. I think these are very good questions, and I think many people ask themselves those questions right now. So the decree indeed created many question marks. It was a surprise for all of us, and in particular, it was not clear what would happen actually with all the pending DIFC LCA arbitrations, whose administration has been more or less paralyzed after the entry into force of the decree. So just as an illustration, our team was unable, for instance, to process payments to arbitrators. It was unable to return surplus funds to the parties. And it's a big issue. As Santosh and Felipe said, arbitrations can be very costly. So for a lot of parties, this was very, very concerning. Also, our team was basically operating without its registrar, who is the only person responsible under the rules to do certain tasks. So, for instance, the registrar is supposed to issue payment directions and authenticate and transmit tribunal supports to the parties. Now, the good news is that Diac has now clarified that all the arbitrations registered after 20th of March of this year could be registered with Diac. So Diac will administer those cases. Now, the question remains what will happen with the pending DIFC-LCA arbitrations. And I cannot give you any answer to this question yet. I understand that Diac and LCA are now negotiating the terms of the agreement on this issue. And I can give you my personal guess. My personal guess is that LCA in London will take over all those cases and will administer them. But please do not quote me on this one. And regarding this first question, you are right to say that now Diac has basically implemented the new arbitration rules. And I believe that there was a pressing need for Diac to update its 2007 arbitration rules in order to remain competitive on the market and also in order to attract more international arbitration users. Now, I believe that these new rules are sophisticated and they are aligned with the best practices of other leading arbitration institutions. So, for instance, they now involve provisions on consolidation, emergency arbitration, joinder, security for costs, etc. They also now provide that the default seat of arbitration shall be DIFC, as opposed to onshore Dubai, which means that the arbitration-friendly DIFC law will apply to procedure aspects of arbitrations, unless, of course, the parties agree otherwise. And, well, that being said, there is always a scope for improvement. So, for instance, Diac could also publish mediation rules. And this is quite important because many DIFC LCA arbitration clauses require the parties to first try to resolve their disputes through mediation as a precondition to arbitration. So Diac is expected to deal with mediation requests in the near future. And maybe one last point, we can mention the establishment of the Diac Arbitration Court, which is now responsible for supervising the administration of Diac cases. And this is, of course, a great development. However, Diac could appoint more international practitioners to its court in order, again, to attract more international users and to increase its attractivity abroad. But overall, I believe that the new rules are a step in the right direction, and I very much look forward to seeing how they are implemented in practice.
Thank you, Antonin. I'd like to basically, so from stemming from what you just said, I think it is imperative that we hear Dr. Rao on this. Dr. Rao, can you have Dr. Rao on screen?
Yeah, can you hear me? Can you hear me?
Yes, Dr. Rao.
Gentlemen, I have had some experience with this many UN organizations. So I'm going to share some knowledge of mine regarding international commercial arbitration and international contracts as well. Now, I want to show to you, one second. Sorry, not this one. I'm sorry. Just a moment. I want to show to you a couple of, the international commercial arbitration that is being, the law that has been created by Unsuitable, and we will see that together, because I would say that this is something which is relatively less known, although there are so many arbitration destinations that we have. But a lot of people are not aware of the Unsuitable model laws on international commercial arbitration. So it's just taking a little bit of time to sort of come on to the screen. And the other thing that I want to talk about is the UNIDROIT principle of international commercial contracts. These both are UN organization. The Unsuitable model is the UN. Unsuitable model is the United Nations Commission on International Trade Law, which has made this model law for all member states of the United Nations. And the UNIDROIT is also the United Nations body, which has. No, this is not coming. I don't know. Sorry. Let me just see if I can just pull this out easily. It's just buffering. So the UNIDROIT is again a UN body, which is a French name, and they have given the contract principles of international commercial contracts. I would urge all of you to look at the UNIDROIT principles of commercial contracts. It's of 2016, and there are numerous principles that are laid out to make international commercial contracts uniform in all aspects. The binding nature, what are mandatory, what provisions could be excluded, good faith, fair hearing, fair dealing, inconsistent behavior. All these things are a part of the UNIDROIT principles of international commercial contracts. And the Unsuitable model of commercial arbitration, I'm sorry, I'm not able to get it out on my computer. Let me try again. Just one moment. Sorry to sort of keep you waiting on this one. But it would be wonderful if you could just see it on the screen. And I have it before me, and I would have. Let me see if it still comes. 1 second. No, this is not working. Anyway, I have mentioned that as and when it comes, I would urge that all of you look at these two aspects of the UN law, which is trying to bring about uniformity among international commercial arbitrations as well as international commercial contracts. And there are standard prescribed formats that are available to you. And most of the destinations, whether it is the Singapore or Hong Kong or the popular destination, even Dubai, perhaps, would be aware of this, these new international commercial arbitration law, which in fact even the Indian Commercial Arbitration Act is incorporated. Organizations, and therefore we are expected to do it. So, and we have set up an arbitration center in the city of Hyderabad, which is conforming to all of these international commercial arbitrations principles which the UN has laid. So, therefore, we can go on with it, and we will just pull it out and come back to the host.
Thank you, Dr. Rao. Because I feel that we from Sir, we started off to Felipe and Antonin, we started from how to see what are the important points of drafting the essential points of drafting the clause for the arbitration. We went on to discuss the financial aspects of the arbitration, and of course, Antonin with a great insight as to what happens when the entire situation comes up to the Diac and the new rules. I'd like to now ask Mumtaz. Mumtaz, what do you think about the latest, the judgment that has come out in India? And I think that is something which is being talked about worldwide. It's a phenomenon, actually, to be very honest, guys. Ladies and gentlemen, we're talking about this judgment of enforceability of emergency arbitration, emergency arbitration awards. And I think there's nobody better than Mumtaz to guide us on that. What do you think about Section 17, the implementation, and what's the way forward for an international community for implementation of these awards in India and, of course, outside India?
So I think Justice Nariman always breaks the barriers. This was one of the very good judgments that he had got. He passed just before his retirement. Why it assumes significance is in a place like India, while everybody has been discussing about the cheap arbitration thing. Now, cheap is a very relative term. I would like to probably use the word expeditious, because in a jurisdiction where I come from, where there's huge pendency of cases everywhere, while justice delayed is justice denied, but if you have a commercial entity which is waiting for justice for years and years, it dies an economic death. So for entities like those, arbitration is the only way forward. And what do you do when you insert a clause like a SIAC clause, which provides for an emergency arbitration, and then you come to India and you want it to be an order under Section 17 of the Indian Arbitration Act. According to the Indian system, the purpose of an arbitration is totally thriving on party autonomy. In India, you can enforce legal rights either by operation of law or by operation of contract. So when parties decide that, we want to get away from the barriers of law and we want to vest this power of deciding our rights and obligations on a third party, it's a choice they exercise. And giving view to this party autonomy that the parties exercise while drafting a contract and entering into a legal arrangement, if they choose a set of rules which provide for emergency arbitration, those rules will apply irrespective of your domestic law. And how Justice Nariman had blended the SIAC rules applicability into Section 17 is also to be seen, because he said under Section 21 of the Indian Arbitration Act, an arbitration proceeding is supposed to commence when you receive a request for arbitration. So in India, anything before a Section 21 request is not an arbitration stage. But if you check the SIAC rules, even a pre-arbitration stage where an emergency arbitration order is granted is a part of the arbitration. So Justice Nariman actually went on to clarify that your arbitrator is not a person who's just adjudicating your disputes post your invocation of arbitration under Section 21. He is also an arbitrator who's deciding your emergency issues when you have by consent agreed to submit to jurisdiction of SIAC rules. Correct. So according to me, it's as clear as it should be. It's the right way forward, because if the party has to go through the perils of filing a Section 17 again or a Section 9 in courts before the tribunal is constituted, what is the purpose of getting into the autonomy and getting into the free consent principle and applying these rules to your contract? Then there are rules in nullity. And if you see the gamut of Section 9 under the Indian Arbitration Act, it says they can pass an order before, during, and even after. And when the word during the arbitration comes, 9(3) says that unless the remedy is expeditious, the matter should be relegated to an arbitral tribunal. So the idea of legislature has never been to take away absolute powers. The idea of the legislature has been to exercise its discretion in a way that complete justice is done. So when a party has chosen SIAC rules, there is an interim order passed by a SIAC emergency arbitrator. It would not make sense to just close your eyes and turn oblivious or be blind to that order and file a separate new application under Section 17 to get a similar relief. So I think it's the best way forward.
Thank you, Mumtaz. I definitely agree with that. So something that I would like Felipe and Antonin to also know about this. So what happens is there is an interim stage of every arbitration, and there's In India, and I find this incredibly amazing, in India there's this thing called a Section 9 and there's the Section 17 for interim relief. In the Section 9, you go to the court, as Mumtaz very rightly mentioned, you can go to the court even before the arbitration is started, during the arbitration, and of course after the arbitration as well. But there is another section called Section 17, that's what we were discussing, and Section 17 is a specific application that has to be moved before the tribunal, and that is the application that you move for an interim relief before the tribunal. And I think that's fantastically said by Mumtaz, and she's put it brilliantly, that this is the choice of the parties and how the contract has been drafted and how do you take it forward. So, ladies and gentlemen, what I'd like to ask you guys is that on each of the topics that we've discussed here, I'd like to ask questions, 1 minute answers, very, very simple. We're going to be discussing because to make it a little more, and of course we can have anybody in the audience who's available, who wants to have a question, we'd be ready for that. So I'd like to start with Antonin first. I mean, it's very imperative for us to understand, ladies and gentlemen, in Dubai, there's a decree 34 of 2021, if I'm saying correctly, right? So decree 34 has played a major role in shifting the trends of arbitration here. We'd definitely like to know what your views are on that, and you take us from there.
Well, I believe that, after the entry into force of this decree, the biggest challenge will be to regain the trust of arbitration practitioners and to gain trust towards Diac arbitrations, and in order to succeed, Diac will basically need to focus its efforts on staff, case management, and innovation. It will need to retain talents. It will need to adopt the best practices in case management, and it will also need to innovate. Diac cannot simply copy what has been done elsewhere. It will need to become a trendsetter on the market and, explore new technologies and new partnership opportunities.
Thank you, Antonin, because this is something that has been, so whatever happens across borders in Dubai, in Singapore, in Hong Kong, and London, especially in reference to arbitration, we always tend to follow what's been happening, and this is something that we'd always want to know something about. Ladies and gentlemen, what has happened here? A quick two-word analysis, what I'd like to bring on everyone's mind here is that from what Saw said, and of course moving on to Antonin and Felipe, and something very amazing said by Dr. Rao, and then Mumtaz. I have a certain view that I'd like to bring on the table. What I personally believe is the first three people that we spoke about, and how beautifully we've rounded up the entire session. I'd like to add that I personally feel that SAZs in particular play a vital role for arbitration, especially in the future. SAZs and arbitration have to be something that has to be seen, and this is something that has now been taken up, of course, by the government of India as well. During the latest budget speech by our Honorable Finance Minister has already announced that there's a new SEZ in Gujarat, and they will be starting up with a new arbitration center specifically for that SEZ in Gujarat. Now that plays a very vital role. Number one, starting off with, if there's a company that wants to invest in India, and these are huge sums of money, thousands and hundreds and thousands of crores and millions of dollars being invested in India, the last thing that this company wants to do is being stuck in any sort of litigation, because that's what I felt when I heard Felipe. And that's what I felt, because it's generally something that we really need to understand, that companies right now are thinking about cost analysis, they're thinking about the time, the effort that goes into all of this. And that is something that really needs to be addressed. So I think partially, not but fully, but partially, if you have arbitrations through SEZs, I think that problem becomes really, it's really solved, because you can bring down costs and make it effective. Because when you have arbitrations in these specific zones, and they have to be done in a specific manner, fast-tracked, and have to bring down the costs, I think what we were promised in the future for arbitration law that it has to be cheaper and faster. That is something that can be, achieved. And I think what Antonin very recently and very rightly said, that in terms of all of this, when you have a commercial dispute, for example, if there is an authority that's no longer, it ceases to exist at some point in time, what happens then? And you are stuck in some sort of a situation, there's a dichotomy, you don't know how to address it, there's a problem, then you want to go to the court. I'm sure how it works in India is that you go to the court. For everything that's wrong in the arbitration sector, you run to the court. But that is not the essence of arbitration, ladies and gentlemen. That is not the essence. If you have to go to court and take out time and fight litigation in court, that at the end of their time is money. And when there are companies who invest in India billions and millions of dollars, they would rather want to have a different route, as Sir mentioned, and of course, as Felipe mentioned, a different route altogether to kind of round out and redressal of the entire situation in one go. What I want to understand is from Felipe that we were discussing outside, that in terms of mediation in Dubai, this is something of a shocker, guys, because I felt, and I've done a lot of mediations in my life, and I felt that mediations are really, really fun for two reasons. One, because in mediations, you can sit and have a complete heart-to-heart talk, solve the issue and come out, which should have been the initial understanding with arbitrations. Arbitrations are supposed to be redressal mechanisms, right? Where you agree in the middle ground and move out. But today it has become some sort of a race for the award, who gets the final judgment, and it should not be like that. So in terms of mediation, and really genuinely, I wanted to talk to you about this. In terms of mediation in Dubai, you said that it's very confidential. Could you throw us some lights on that, please?
Thank you for the question, and it was a great conversation that we had earlier today. So I guess the first thing about this topic is the concept of without prejudice. It's not necessarily widespread, and this is sometimes difficult to grasp by lawyers educated in common law countries, lawyers in the UK, lawyers in the US, lawyers in India. The without prejudice concept is something that it's inbreeded in everyone. In civil law countries like the UAE and in many countries in the GCC and in the Middle East, that concept is not there. That means that any conversation, any interaction, any exchange of letters during a negotiation or a settlement are fair game for litigation. And that changes the stakes dramatically, because if you cannot have interactions without prejudice, then you are very careful on what you put on the table, what you offer, how you address the other party. And that is sometimes very difficult for common law lawyers to grasp. I'm a civil law lawyer, so for me it's actually very common to know that on a settlement discussion, everything can be used against you. But that's the big difference. So with the new mediation law that was mentioned, this point was addressed by the common law community, saying that still hasn't been applied in the UAE. Even though the mediation law has a very strong confidentiality provision, saying that everything that you discuss during a mediation under the center rules and under the procedural rules is going to be kept confidential, but still, that doesn't address the problem of the without prejudice. And as everyone in this room knows, confidentiality has always exceptions. So there's always an exception of public order, there's exceptions of legal requirements, judicial requirements. So even if there's confidentiality, it doesn't guarantee that the communications exchanged during a mediation could eventually come out against you for litigation. And I think that's a big issue in general for civil law countries. It's something to be aware of, and I think something that hasn't been fixed with the new law.
Thank you, sir. Because something, I'd like to add something without prejudice, of course. So this is something which I was discussing outside, and I'd like you guys also to kind of, understand that the words that we use during negotiations, drafting of a contract, or even as simple as what sir mentioned as an email, when you write things like without prejudice, and then you go on to write about all the prejudices that you felt across the negotiations in that email, right? I think that plays a very vital role here. Because what we do in India, and I think that's the practice across, because we do cross-border transaction advisory, and we've felt that especially firms in Europe, firms in the US, firms, of course, in UK, it covers Europe, they have a habit of writing without prejudice and then enumerating all the prejudices they have. And then ending it with warm regards. So that's something that Dubai has now, of course, UAE has now taken care of. What I really want to understand is that I think Dr. Rao would like to mention his presentation. Dr. Rao, you're now
Yeah. Are
you're
you
now
able
live.
to see? Are you able to see the UNIDROIT principles of international commercial contracts on your screen?
Yes, Dr. Rao, it's very, very visible.
Yeah. Now the UNIDROIT is a French term, and this is the International Institute for Unification of Private International Law. So that now UNIDROIT is the International Institute for Unification of Private International Law is a well-recognized UN body which is doing enormous amount of work in standardizing of international commercial contracts. So as you can see, this is a 34-page, and it's got all the articles dealing with every aspect of a commercial contract. Formation and like for instance, formation and authority of agents, and it's just like any law which we have in our statute books. And it contains most of. Now the United Nations has tried to develop a standardized form of international commercial contract, and the UNIDROIT principles of contract, which are in this form, which is as late as 2016, as you can see it, is what is being adopted worldwide, and gradually you will find all destinations doing international commercial arbitration looking at contracts which are made on these principles. Now, the other thing which I wanted to share with you is the Unsuitable model of commercial arbitration, and that is the United Nations Commission on International Trade Law, and I'm sure we'll be able to see that as well here. Now, can you see that on your screen? No, I'm sorry. Just a moment. This is not the one. I will just show you the other Unsuitable model of commercial contracts. Again. I'm sorry, it's been a bad.
I think that's the same. That's the same template.
No, just a moment. I just had it with me in a moment, and because the PDF file sharing of the files is different, and may I just try to open this one? 1 second. I think no. 1 second. So just here with me. Give me a second. This has been such a disaster today. I've not had such a bad day for a long time. There you are. Oh, voila. Now you see the Unsuitable model law on international commercial arbitration. Now this is the United Nations Commission on International Trade Law. And I'm sharing with you some knowledge. All of you are very knowledgeable in your own way, and you may be knowing various arbitration destinations. And this, as you can see, is a complete UN body, unlike the UNIDROIT. And it has got amendment as late as 2006. And I'm going to see now. You see the model law. Some of our laws, the Arbitration and Conciliation Act of India has also been, adopted on these lines, and it has got various. I don't want to. I mean, of course, we are short of time. But if you look at it, recognition and enforcement of interim measures, conduct of arbitral proceedings, making of award and determination of proceedings, every single aspect of an international commercial arbitration has been laid out in this. Now you see, kindly see the General Assembly. This passed by the UN General Assembly, Recognizing the value of arbitration as a method of settling disputes arising in international commercial relations, convinced that the establishment of a model law on arbitration that is acceptable to states with different social and economic systems contributes to the development of harmonious international economic relations, noting that the model law on international commercial law is adopted by the UN Commission on International Trade Law at its 80th session. After due deliberation and extensive consultation with arbitral institutions and individual experts on international arbitrage, convinced that the model law, together with the Convention on the Recognition and Enforcement and Foreign Arbitral Award and the arbitration rules of the United Nations Commission on International Trade Law, recommended by the General Assembly at its resolution of 31 and 15 December 76, significantly contributes to the establishment of a unified legal framework for the fair and efficient settlement of disputes arising in international commercial relations. So now this was adopted, and this is adopted with a view that we can have a unified, standardized kind of international commercial arbitration law, which should be adopted at London. I would advise that you take this up with your clients before, or you read it up and look at the various aspects of these two, the UNIDROIT principles of international commercial contracts, as well as the Unsuitable model of international commercial arbitration laws, before you embark upon arbitrations anywhere. And I think I've taken much of your time, and I've been in difficulty with presentations. So thank you very much.
Thank you, Dr. Rao. Thank you so much. Dr. Rao, before you leave, just one question. Dr. Rao, the template that you've just presented,
Yeah.
it's shared, Dr. Rao. I think it's fantastic. What I wanted to understand is something that would you see this to be something that can be adopted in the future in some sort of an SEZ uniform model across the world, or maybe just as a standard form of arbitration?
Yes, that is exactly. That's why I read those provisions to show that you see there are 192 countries in the United Nations. So therefore, most of the countries in the world which are doing trade and commerce between themselves and with their citizens doing,
Right.
interacting, they're all signatories, and they have adopted this law as a standardized format of law. And I would therefore urge all of you lawyers to look at these things, get a copy. It's easily available. You can download it from the Unsuitable. I attended some of these sessions, and it was the deliberations were
Thank
very
you, Dr.
intense.
Rao.
Some of the best experts in these areas have worked on this field. And when you look through it before you sign up a contract or advise a client, or you incorporate the arbitration clause, you will be benefited enormously, and you will find that gradually all destinations having international commercial arbitration will be adopting this.
Thank you, Dr. Rao. I think that's very, very insightful, and I think that will solve the problem. I think it should solve the problem. What, of course, Sir mentioned, that when you have the New York Convention and then you have different jurisdictions, that if you have a uniform set of the United Nations model of the arbitration commercial dispute resolution system placed across the world, I think that is something that will solve this problem immensely. But I would like to ask one question, 1 minute. I think we have to wrap up after this. Mumtaz, I'm going to start with you. In terms of what you said, and because arbitration in the entirety has been brought up in the international community, and there's an imminent need for implementation of some sort of an execution mechanism. But of course, you know this better than most of us, that in the Indian courts, then you have 34 and 34.4 section that involves the High Court to enter into the arbitration proceedings. So ladies and gentlemen, the 34 section of the Arbitration Act basically speaks about when there's an award passed, and then where you have to challenge the award in the court. Of course, there are very limited grounds on which you will win the award and it gets overturned. And there are, of course, public policy being one of the most prominent being used across the world. I would like to know your thoughts on 34.4, building on what Sir said and what Dr. Rao said. And 1 minute. I'm sorry.
So section 34 is really peculiar because Like I said about party autonomy, the Indian Arbitration Act does not provide for an appeal on merits. So you can't just be unhappy with an award on merits and just go to a high court. I'm not saying it's not done, but it's not legally allowed. So the idea behind an award in arbitration is whatever the arbitrator chosen by you decides, that award is final and binding on the parties. You can assail that award on certain grounds. The most important ground used and misused in India is violation of public policy, but that's a separate topic altogether, which I'll come to, in some other discussion. Here, 34.4 assumes significance because the idea of an award is it should be final and binding, and if there are any errors and defects in an award, they should be removed to uphold the sanctity of the award. So when the High Court, when an appeal is filed in the High Court under Section 34 of the Indian Arbitration Act, and the High Court feels that the award is perfectly on point on the issue of finding, but there can be reasons supplanted by the High Court on the award, essentially retaining the nature of award. What the High Court usually does is, upon a request made by one of the parties, it adjourns the proceeding for a given period of time. It can be 3 months, it's 6 months, and sends the award back to the arbitrator to supplant reasons in the award. Now, this is important because once an award is passed, an arbitrator becomes functus officio, so he loses his power over the subject matter. But the High Court gives this power back to the High Court, to the arbitrator, to supplant reasons and make the award, maybe a 90% award into a 100% award, because the High Court also understands and appreciates that going through the entire process of a 34, which is a lengthy and tedious process, and giving the same award with a couple of better reasons which can satisfy the conscience of the party which is moving the Section 34 application in court, it doesn't make sense. It's better and it's quicker to send it back to the arbitrator and say, okay, while your finding is there on reasons, but your reasons are not sufficient enough. Why don't you supplant reasons on that? And this has been taken up in a lot of cases where parties have in fact filed Section 34 for applications seeking a reference of the dispute back to the arbitrator where there have been no finding. Now that's different. You need to understand the difference between a lack of reason and a lack of finding. If there is a finding that, for example, there was a contract termination, there's a finding that the termination was legal or illegal, and these were the breaches, it's fine if the reasons can be supplanted. But in the absence of an issue being framed and a finding not rendered, then the arbitral tribunal will not have the power. Then the High Court will have to either set aside or approve the award in a 34 application. So yeah, this is also another measure under the Indian Arbitration Act to facilitate the conclusivity of an arbitration proceeding so that you are away from courts as long as you can.
Mumtaz, we have a question from someone, Mr. Krishnan Singhania, Managing Partner, Singhania and Company, Mumbai. The question is, do they have to go to court to make it enforceable?
Make what enforceable?
The
An arbitration award.
Yes.
If the party doesn't adhere to an award, yes, execution of an award, we have to file an application for execution of an award.
All right.
As far, I think if his question is if we have to go to court for an application to correct the error, the award and remove the defects in the award, yes, and it can only happen once a Section 34 application to challenge the award is filed by one party. Then the other party, which is the decree holder, is going to file an application under 34.4 saying, look, there are reasons in the award, there are findings in the award, but the reasons are lacking. Please send it back to the arbitrator. He's going to supplant reasons in this. But if the court it's a totally discretionary power with the court. The court is not obligated to remand the matter back to the arbitrator. Remand is not the right word because remand is not a power the High Court anyways has.
Correct.
But send it back to the arbitral tribunal, because if the reasons are not there, the reasons can be supplanted by the arbitral tribunal. But if the finding is not there, it goes to the root of the award itself. It has to be set aside by a court in a Section 34 application.
True. Actually, he's given us like a proper question. It says that if the emergency arbitration provisions are provided under law in any country, then do courts in that country recognize the emergency arbitration award as enforceable given by an arbitral tribunal? I think this is an issue that has been dealt, yes.
Yeah, so he's already answered it. You have to see if the country is
Yes,
recognized.
and I think the Amazon Future Group, the entire discussion has been based on that. And thank you, sir, you've covered it. What we'd like to do is like to take a 10-minute break from the discussion, ladies and gentlemen, and we'll be wrapping up after that. So we have questions. If you want to take questions right now, we have Mr. Gunasinan sir, who has a question. Can you have the mic? So we can have the 10-minute break later, because I was told there has to be a 10-minute drink break.
We need full break.
He needs a mic.
Yeah, thank you. Thank you, Somesh. It's a break from Somesh, actually. Now, from the topic, which is tips, best practices, and hot buttons, issues of commercial, mediation, and arbitration. Two questions which I have got for the panelists. One is for Mr. Santosh, the other is for both the other panelists. Point is this: you are focusing on arbitration as an alternate to litigation. Two, arbitration as an alternate, you are focusing more on the cost effectiveness, financial aspects of it. My point is this, my question actually is this. With the coming into the force of the Singapore Convention, which is specifically on enforcement of mediated settlement agreements, which happens only in commercial causes, commercial contracts. Among the countries that ratified the treaty, I think almost about 63 countries have ratified the treaty. So, when you draft an alternate dispute resolution clause in an agreement, what importance you are giving for mediation as a primary alternate dispute resolution, rather than go for arbitration, ultimately end up in litigation?
I think as a commercial...
One question. Secondly, so far as the arbitral institutions are concerned, there's always an option of Arb-Med-Arb protocol. So during the pendency of an arbitral proceeding, if there is a possibility that the parties could come to an agreement on or settlement of the dispute, it is always open to the arbitrator to refer the parties for mediation or conciliation and arrive at a settlement, thereafter come back and award to be passed. Have these positions been taken into consideration by the in-house counsels as well as for the entire position to the panelists as a whole? Thank you.
Thank you, sir. I think there are two questions. There are two persons, and this is for the entire panel. The first question is that when you draft an arbitration clause in a contract, what importance do you give to mediation in drafting of such a clause? And secondly, if I'm getting it right, sir, and secondly, during an arbitration, if there occurs a possibility of a mediation, what would you do? I mean, what will be the way forward from there? Correct. So I think firstly, sir will take it, and then Mumtaz, and then sir, and I'm going to take it in the end. So one by one, sir.
Okay, so I think when I said alternative dispute resolution, most of the time when we are dealing in a corporate, we have got an intention of do cost-effective dispute resolution. So it's not just alternative, we talk about a proper dispute resolution. And as you ask about the mediation, normally we don't put specific mediation clauses in our commercial contract, but there is always a mediation element there, because if you look at any of the arbitration clause, also any dispute resolution clause, actually in the dispute resolution clause we start with a friendly discussion. So the friendly discussion between both the parties, and then both the parties will try their level best, and always, and some timeline is also set up in the clauses that okay, up to this time they will do a friendly discussion, and then if they are not satisfied, then they can go for the other dispute resolution. So mediation is always there, because friendly discussion is what? It's mediation. Without the help of an external party, we are doing a mediation. And commercial organization point of view, I think that every commercial organization will try its level best to do the sort of a mediation before actually going into a litigation or going into an arbitration. Because I mean, if you ask me, okay, what is the killing point of deciding that whether we should go for arbitration or not, I, as a general counsel, if I have to advise to my business team, I will definitely say that if you have got a chances of winning even 60%, try to settle. So until unless there is any possibility of settlement, do it. You can win it. You have got a 60% chances of winning in arbitration. But my advice would still be there that try to settle, try to negotiate, try to find out if we can find something else. So mediation is always there.
Mumtaz, would you like to take this?
So, India is also, as a market, getting very serious on mediation now, with mediation bill also having been, given some serious shape. I do have my reservations on the nature of the bill, but MEDAB or mediation as a concept is a very welcome concept where things are capable of being resolved. The fact that mediations don't have any finality attached to them till the parties consent to it, I think that's where the restlessness of the companies come in. So where the money is involved, where urgent decisions are to be made, where there's an interim relief that's required, or there's an urgent action that's required. While it's advisable to have a qualified mediator who can understand, intervene, and mediate between the issues, but mediation is always very onerous. You can decide to go ahead with it, you can decide to totally brush it aside. And what is the intent of the party getting into the mediation? If today I want an urgent relief for my client, and the other party is recommending mediation, and I know that they're not going to settle anything with me, am I going to wait for mediation, or am I going to invoke arbitration and protect my client? Why arbitration is always most preferred is, yes, it's an alternate dispute resolution mechanism. Why it's preferred is because of the finality you get with it, because of the legality you get with it. In a mediation, I could have 4 rounds of mediation, waste the other party's time if I intentionally want to, resulting in no legal obligations on either side. So I feel that it all depends on the situation you're faced at. Yes, mediation is always recommended. I've barely come across any contract where there's no clause for friendly discussions, and law is very clear. When there's a gamut of procedure given, you have to follow it. There has to be a notice for friendly discussion, then you invoke arbitration. But to give seriousness to what you want and how urgency your dispute is at that stage, definitely arbitration. And like I said, arbitration is, it's a subjective term whether it's cheap or not. If you compare it to a jurisdiction like India, where your entire arbitration claim can be decided in what prior to the earlier act, your claim was decided in years and years, but now with the new act, your claim gets decided in a year, maximum 2 years. But if you compare it to a litigation which after 10-15 years, you're not even at the stage of evidence, do you really say it's not cheap? It is cheap, because you entail legal costs, you get legal counsel fees, you get your legal exhaustion, and then you die in economic debt. So I feel that when you use the word cheap, it's a very subjective and relative term. It's the right word is expeditious, it's cost effective, and it's quick. So that's my view about the whole thing.
Thank you, Mumtaz. So you'd like to take this from the question, you need to answer him.
Okay, my take is the following. I got 3 comments. First comment is, in some jurisdictions, it's actually compulsory. Before moving to litigation or arbitration even, you have to show some sort of trying or attempt to settle, sometimes even mediation. So that's the first comment. Second comment is, I guess companies have different policies. I've seen both. I've seen companies that include in their templates always a mediation clause. I've seen that happening in my particular experience in South Africa. I've seen those clauses very, very descriptive of what the mediation process must have before moving to either litigation or arbitration. I've seen that. And I've seen other companies do exactly the opposite, have removed any single reference to a mediation or a settlement before doing arbitration. My personal preference is to remove any reference. And the reason is the following. If you want to arbitrate and you have in your contract those conditions about mediation or previous understandings or previous settlements, if you want to go to an arbitration, it's very easy for the other party to challenge that arbitration, saying that you didn't do enough to reach a settlement. So it's actually shooting yourself in the foot by putting a very thorough condition about mediation or settlement if you at the end want to arbitrate, because it's giving the other party the advantage to challenge that arbitration and say, well, you know what, you need to give me notice, you needed to give me previous warning, you needed to summon me to, you can put a lot of conditions. So in my experience, I actually rather have no reference to mediation and just have the arbitration clause. And if things are good and you can reach a settlement, you can always reach a settlement regardless of what says in the contract, but still much better to move to arbitration. So that's my take.
And then would you like to add on this?
Yeah, so I'm mindful of the time, and I can imagine that everyone looks forward to the tea and coffee, so I will be very, very brief. I would just add that from our experience, we have noticed that parties more often refer to mediation in their arbitration clauses, and they often require mediation as a precondition to arbitration. So for instance, last year, we had, I believe, 7 mediations, which was the record number. Of course, you know, arbitrations, it's our main part of our caseload, but we do have some mediations as well. And I completely agree with what Felipe said about the wording of these clauses, because often it's very unclear whether the parties intended this pre-step to be mandatory and whether this pre-step has been satisfied. So we have noticed that different tribunals have reached different solutions to very similarly drafted clauses. So if you really want a pre-arbitration step to be mandatory, please specify it and be as clear as possible.
I hope, sir, that answers your question a little bit.
Hello.
But I'd like to, I know, sir, there are 2 more questions coming up. 3, 4, maybe, well, okay, 4 questions. We'll get to you from once you've answered Gunasinglan, sir, totally. Sir, to wind up all of this, so my personal view for mediation is that in terms of, even when you go for an arbitration, it's a sort of a negotiation. It should be a sort of a negotiation to come to an amicable settlement, right? If you fail to do that in an arbitration, you fail to do that in a mediation. I don't think, how would you enforce that in a mediation? Mediation will still never work, right? Every contract that has ever been enforced, there's a line that says, very rightly, what sir mentioned, that there's a line that says that after failing to reach an amicable settlement, then we'll go for the arbitration. This is the person we want to appoint, and something like that. So that's, I mean, you know, a little personal view. Moving on, I think, sir, we've answered your question. I think Manveen, sir, has a question. Can we have a mic?
Hi, if the arbitrator starts a mediation and the mediation fails and the arbitrator does not want to remit office, what steps do we take in such case? Non-politically correct tips, please.
Thank you, sir. Could you just repeat the question again, because we couldn't hear the second part?
Sure.
If the arbitrator
commences mediation, like if there's a mediation which starts and the arbitrator acts as a mediator, and then the mediation fails, but the arbitrator still wants to continue as an arbitrator in the same dispute, how do you sort of like nudge him to remit office?
I'd like to take this question first, and then I think Mumtaz will take it. Sir, to be very honest, as a counsel for any of the parties who's doing this, I would be totally fine for two reasons. I would like to be my arbitrator to be well versed with the issue, with the dispute in hand, and what the relative terms of the redressal should be. I am totally fine with the person continuing with it, as far as he has total understanding of the dispute, the entire the enormity of the dispute involved, and the party's skill of negotiating. And if he wants to continue as an arbitrator, I personally feel no point. I'll tell you why. When he continues an arbitrator, as a mediator, in mediation you can't enforce what you've decided, right? Because it's not enforceable. But an award is much more enforceable. It has more sanctity in law. I would prefer that. To be very honest, sir, I'm on the same page as you are. I would prefer my efforts over the period of 4 months to culminate into an award that is enforceable, rather than into a mediation which is then agreed and then later not agreed. And I think Mumtaz would want to add on to that.
So I have a different view, Manavendra. Non-politically correct or politically correct? No, I don't think they should be the same.
Politically correct.
They should be the same. That was his question. That you don't have to be politically correct. So I don't agree, because mediation is a different process altogether, where there are without prejudice discussions. Parties come up and talk about where they lack in the issues, what are their weak points, and how to overcome those weaknesses in terms of a mediation proceeding. Now, an arbitrator who sits as a mediator, I'm giving my personal view, an arbitrator who sits as a mediator will be very well versed with what the actual dispute is, where both the parties stand. And such a person acting as an arbitrator subsequent to that may not be very fair and independent, even if he wants to be, even if he doesn't take sides, because he will understand the aspect. If he's reading some pleading, he will have a background to it which he had heard in the mediation. He will never be able to render an independent and impartial decision. So according to me, since the entire process, the legality, the enforceability of both the processes are different, parties are more open and more forthcoming in a mediation because it's a without prejudice discussion. That same person cannot act as an arbitrator, because he will have a view of the whole situation which he will not have if he just starts as an arbitrator. If you issue a notice of invocation of arbitration, you have an arbitrator appointed. He goes on to hear your arbitration proceedings. He sees your statement of claim. He doesn't have your weaknesses on his mind. But if the same person is doing it, he knows more than he's supposed to know. So I think that's where the independence and fairness lacks. So according to me, it's not a good idea.
Yeah, correct. I think, sir, would you like to take this, and then I think Antonin, and then Felipe. Antonin wants to say something. Do you want to add on to that something?
Yes, I would like to jump in. Sorry, I would like to jump in and just mention that I completely agree with Mumtaz said, that it's two different processes, and this is also why under our DIFCLCA rules and Diac rules, the default position is that if the mediation fails, the mediator cannot act as an arbitrator. Of course, if the parties agree otherwise, yes, he can then be appointed as arbitrator, but the default position is that it's another person who will act as an arbitrator.
Felipe, would you like to add on that? No. Just one question, sir. I hope we've answered the question. There's been some sort of a majority wins sort of a situation. Yeah. We have one question for Harsh. 1 second, and we have time for one last question. And I think sir has been raising his hand a little earlier than that. Can we have the mic to sir? Yeah, sir.
Actually, I wanted to ask two questions. So first question is almost answered, because the panel is entirely towards the mediation, towards the arbitration rather than the mediation. So I am a court and ex mediator since 2007, and I'm a commercial mediator also, accredited by the ADR, ODR London, and SIMI Singapore. So I'm more inclined towards mediation, so that discussion can go on for so I personally believe that mediation is the way to go, and in few years we'll be sitting here all saying that yes, we want mediation. one thing, only in one line, I'll say why I'm saying this. Because from moving on to, we say ADR, alternate dispute resolution. So moving on from adversarial towards the settlement is what mediation is. Even arbitration, we have to decide. Mediation, we don't settle, the mediators don't settle, it is the parties who settle. So that is a long discussion. So I'll skip the first part. I'll go on to the second part. As far as the arbitration is concerned, why is India lacking on big arbitration cases? Why is Singapore, Dubai, or London are the most preferred seats? Why not India?
All right. Mumtaz has just mentioned that she'd like to take this. Ma'am, you can go ahead.
Being a litigation lawyer, I think I should answer this when it's about India. So India is still lacking. While it's picking up, India is still lacking because of the love Indians have to move courts, even in an arbitration proceeding. So even if you have an award in your favor, it goes through a process of 34 and then to the Supreme Court. Nobody is going to give it up till they go up to the Supreme Court, depending on the stakes involved. You'll find if there are 100% people who litigate or arbitrate, maybe 5% are the ones who are like, okay, let's accept this and move on because I've spent enough amount of money in the legal cost. But everybody else really intends to go to the final stage of Supreme Court. That's one part of it. The second part of it is interference by courts during an interim stage for preservation of subject matter of property. Now, Section 9 is a very draconian provision. It's required, yes, but it's very draconian. It's very often resorted to the moment a dispute is ripe. You will see more often than not one party or the other moving the court in a Section 9 application seeking an interim relief from the court before an arbitral tribunal is constituted. Now, this also assumes significance because about 6 years back or 7 years back, people used to take interim reliefs from court, sit over it and not initiate arbitration. Now you have the new act, within 90 days, you're supposed to initiate arbitration. So India still lacks because the interference by courts still remains quite a bit. And this is what has been often said by lawyers in courts. And this is one of the reasons, I think, why Justice Rohington Nariman had given these unconventional decisions, because he was on this side of the bar. As a lawyer, he had faced these issues with his client more often than not, that, clients were losing interest in India as a market because they knew that anything having India as a seat of jurisdiction, even in an international commercial arbitration, meant the dispute is at least gone for 5, 7 years or 10 years, and parties would be compelled to settle the dispute, getting tired of their arbitration and the litigation that follows the arbitration. So I think that's the only reason where it lacks, because if you see a jurisdiction abroad, they're not scared of, shying away of throwing away a petition on the first day, saying, this is final, this is what you decided to. In India, we are somehow, able to twist and turn everything and bring it within the purview of a Section 34 application, despite the fact that the Section 34 application is not an appeal on merits. So I think that's where the confidence is lacking.
Sir, I hope that, because to kind of a little sum up before what ma'am said, that yes, there is of course there is a long way ahead for mediation to pick up in India. A very huge part of this is because India is a very litigious country. As ma'am said, that we fight it till the end, to the last bite, to the last drop of blood. We would like to get the award, and that is enforceable. But the idea is that I think you're right, that after maybe a couple of years, mediation is going to take place. I would personally feel that, sir, because I understand that once you mediate and settle, of course, the parties settle, the dispute over there is ended. Like, there is no scope, and there's very, very limited scope even after that to go on further, right? But as long as you're fighting, there is fighting and fighting going on between parties, then of course, there is, of course, different rounds of litigation that follow. So, of course, mediation has to come up because it's time saving. Any dispute redressal system in the world which saves time, which is efficacious, which is enforceable, and of course, we will not say cheap because it's, ma'am said, it's subjective. But if it's affordable, I think that will essentially be the future. I think I completely agree with you. I think Harsh, sir, you have a follow up, I think.
It's completely answered my question. Just one follow-up for Felipe. UAE has also signed the Singapore Convention for Mediation.
Okay.
It has become the 56th signatory to the convention.
You want to answer that on UAE, sir? For mediation. Okay. So has that been answered properly? All right. I think I will give you 5 minutes, Harsh, for this question, because then we'll have to wrap up. Yeah.
First of all, this was a very interesting discussion. I'm Harsh Trivedi. I'm a managing partner in India with my own law firm. My question is, we talked about mediation. My first question is to my esteemed guests here. First one is that as corporate lawyers, right, we draft contracts, but as litigators, we end up defending it. So as we say, corporate lawyers are more boardroom lawyers and litigators are more courtroom lawyers per se. My question is that for Mr. G.V. Rao, I'm looking forward to connect with him if you could answer this question, sir. With your experience, what would you say as a designated senior advocate of the Supreme Court, that does this practice ultimately hurt the interest of the client? Because as litigators, we are the ones who end up defending the clauses of the contract in a court of law. That's my first question. Second question is on two-tier arbitration. We are talking about great aspects of mediation when it comes to arbitration. One, as per Unicitral model of law, it might just require some amendments in it, wherein it's stated that even an arbitrator should have the power to refer to a matter to mediation, because I think Bhalla correctly said that it's very subjective. As a lawyer, we would always press for arbitration to save the interest and time of the client. So should the arbitrator have the power to refer a matter to mediation? Secondly, in terms of two-tier arbitration, shouldn't be a factor that an arbitral award, because it's an ADR mechanism, should be challenged by a second round of arbitration with a very limited scope of question of law. Thank you.
I think this question is for Dr. Rao, if he's available on screen. Dr. Rao.
Yeah, what was the question? I'm sorry. I am sorry. Can the question be repeated? I was little paying attention.
Yes. Harsh, you have to repeat the question.
I'm so sorry.
Part one.
I'll sum it up, sir. My question is that corporate lawyers, in-house counsel teams, they tend to draft agreements, contracts. But when that clause is put forward before it's questioned or it's under dispute before a court, so this normal practice that a corporate lawyer will draft a contract and a litigator will end up defending it in a court of law, is this a practice which is in the interest of the client? Because ultimately the level of experience and exposure which a litigator has while defending a particular clause of arbitration or anything else, so shouldn't the onus be on litigators to start drafting contracts?
Absolutely. I'll give you an example. You know what happened many years ago? This is almost about 2 decades ago. I had a client from who was doing a contract with a party in Hong Kong. So the arbitration clause in that was that the arbitration will take place in Hong Kong, and I drafted the clause that there would be discussions for settlement, and the party in India, who was my client, would not go to a court of law. He himself, I drafted, I even showed it to Fali Nariman, in fact, and Fali Nariman was very impressed that how did you do that? I said that's an undertaking I take upon myself to resolve the issue before I go to a court of law. So therefore, a litigator will have a great experience, including the lady Mumtaz, I'm sorry if I got your name right or not, has so much experience in litigation that she could draft a perfect clause, in a contract. So always, I would suggest in-house counsel should vet their contracts by litigators who are day in and day out in courts, who understand what's been happening in the courts. So it's a very good question you've asked, and it will open eyes and for people to look at it, that they should consult litigators to run it by them to see if it would ultimately create some kind of an issue in tomorrow in a litigation. So that's a good valid point. I appreciate it. I think that's what is the right way to go about it. And I think litigators can do a great job of drafting clauses because they are they are well aware of the possibilities of what are the problems that one could run into.
Correct, sir. The basically what the idea of risk assessment and what basically comes to court and how to defend it. If you have the ability to have the foresight to see it and you draft accordingly. I think Harsh, your question has been answered. We have time for one more question, but I saw
Hi, this
he's
is
already raised. I'm really sorry.
my name is Hitesh Soni, and I'm the
Could you speak
founder.
a little louder because
My name is Hitesh Soni, and I'm the founder and managing director of Hitesh Soni and Associates Mumbai. I have a brief question to ask to Mumtaz and Antonin. That in India we have arbitration when there is no arbitration clause. For example, we go to arbitrator and refer some clause and submit our claim. And if our parties have not submitted to the the procedure, the arbitrator is a master of procedure under section 19, if you know. So what is the treatment we have in SIAC and in other part of the world in respect of similar clauses is there, how we treat there?
If I get your question right, you're saying that in India is mainly focused on ad hoc arbitrations and not institutional arbitrations. How do institutional arbitrations work out? Is that your question?
Yes.
Okay. So I think I won't disagree with this that India is majorly focused towards ad hoc arbitrations, but for the smaller disputes. Even for the bigger disputes, yes, but over the last 1 decade, how I have seen things working out, the focus has been only towards SIAC and ICC. MCI is picking up. DIAC is picking up. DIAC is picking up because of the cost factor that it brings in. It's again a very cost effective remedy. But why parties usually prefer an ad hoc arbitration in India is because the contracts are drafted by lawyers who don't carry the requisite experience to draft such formal clauses. Because in India, almost every commercial contract has an ad hoc arbitration. Sometimes the parties want this flexibility of an ad hoc arbitration because it gives them the choice to choose their own preferred arbitrator. So if my client comes to me and my client tells me that I want to have a retired Supreme Court judge as an arbitrator, what do I do now? I don't tell him that you go to SIAC or go to ICC. While there would be a lot of retired judges in the DIC panel as well, but I would say that have a 3-member tribunal clause and let it be an ad hoc arbitration. But SIAC and ICC are very, very formal procedures. You have to give a request to the secretariat, and it's they who pick an arbitrator for you. So I don't know why in India people are still reluctant to give this power to another authority, except when it's a big corporate. Big corporates, big contracts, they still feel it's more systematic because there'll be more independence. But for the other contract, a larger mindset, I won't bifurcate this on the financial aspect, I would bifurcate it on the mindset aspect. Most of the mindsets that I have seen is towards having their choice of an arbitrator. And if you have a SIAC or an ICC arbitration, you can't just say that this is my right to exercise and appoint an arbitrator. I want to appoint this person and that person. You can do that in very exceptional cases, but you lose that power. And obviously, when the secretariat appoints it, multinationals are happy with it because they feel it's a totally independent procedure. You don't even need to have a 3-member tribunal. Often in India, in an ad hoc arbitration, you will see there's a 3-member tribunal because if there's a sole arbitrator provision, the parties will never agree on a name. One party will recommend a name, the other party is going to reject it, on maybe merely a conjecture or a surmise that maybe the independence is not there. So what happens? Everything is either a 3-member tribunal or a 5-member tribunal, and obviously it becomes an expensive exercise. But if you go to a SIAC or a MCI or a DISC or an ICC arbitration, you have an appointment from the secretariat about a person you would never know. It's like your court appoints in a Section 11 application. So instead of going to a court for a Section 11 application, you are suggesting a nominee. It depends on how your clause is worded. If your clause says SIAC is going to appoint, they will appoint one arbitrator from its panel. It's going to be quicker, it's going to be more effective because you don't have to fight for dates for everybody to be together and things like that. But if it says that you can appoint it and the SIAC rules would apply, then it's different. So yeah.
Sir, I hope that answers your question to a bit, or do you have a follow-up? Yep, that answers your question. We got a thumbs up. And I think that would bring us to the end of the panel of discussion. I'd like to thank all my panelists for coming up here, giving on your time, and this has been really fun. Thank you so much, everyone.